Earlier this month, a federal judge in California struck down the state's long-standing assault weapons ban. This thing had been in effect for 30 years until the Honorable Roger Benitez, federal judge in California and also the patron saint of the Second Amendment in California, comes in and says, no. This thing is way too broad, and it covers guns that are protected by the Second Amendment as we understand it through Antonin Scalia's beautifully written decision in DC versus Heller. He says that this ban effectively covers the AR-15. Since it covers the AR-15, and that is the most popular rifle platform in the United States, this is not a ban covering fringe weapons or dangerous weapons or particularly harmful weapons. Rather, it's covering average gun owners with an average gun under average lawful purposes. There's nothing on the fringes here. This strikes at the very, very core of the Second Amendment. Now, of course, the state of California is appealing this, and they want their ban reinstated. This will go up to the Ninth Circuit Court of Appeals, and in that vein, 22 other states have now come in and urged the Ninth Circuit Court of Appeals to keep the repeal on the ban in place, as in to allow Californians to own AR-15s, to say that this ban is unconstitutional. 22 states led by Arizona Attorney General Mark Brnovich, who is quickly, as I learn more about him, becoming quite the star. So maybe more stories about Mark Brnovich to come. Who knows? We'll see. Let's take a look at what's going on in this case, talk about the implications of it, and why these states are urging the Ninth Circuit to find this ban to be unconstitutional. All right, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Whichever platform you're watching on, please go ahead, hit like, hit subscribe, turn on your notifications. Make sure you don't miss any future videos. Okay, here we go. California assault weapons ban repeal should stay. 22 states urge Ninth Circuit. Lower court struck down 3-decade ban earlier this month. This is from Fox News. The link to this story is going to be down in the description. If you want to check it out, you certainly can. So here we go. A coalition of 22 states on Wednesday, that's today, this is breaking news, announced it has filed a court brief in support of a decision that struck down California's ban on assault weapons, which liberal state has now appealed to the Ninth Circuit Court. Coalition led by Arizona is urging the Ninth Circuit to uphold a lower court decision to strike down the 3-decade ban on the state's definition of illegal military-style rifles. A federal judge overturned the ban with a permanent injunction earlier this month. It has given the state 30 days to appeal, which it is doing. California's first restricted such weapons in 1989 and updated the law multiple times, defining the nebulous term assault weapon in such a way that the judge said there are 185,569 assault weapons in California alone. The Republican states argued in their amicus brief that the law strikes at the Second Amendment by targeting guns that are used by millions of law-abiding citizens for a myriad of lawful purposes. The other thing the judge does in this article is he talks about just how rare rifle killings actually are in California and in the broader United States. The overwhelming majority of gun crime is committed with handguns. That is the overwhelming majority. And rifle crimes are not actually broken down by which specific rifle. It's all rifles. So to say that assault weapons are particularly assault weapons, I'm using it in the way that they're using it. I know there's no such thing as an assault weapon. Go ahead and jump down my throat in the comments or whatever, but listen, they're calling them assault weapons. I know that that's not a real thing. AR doesn't stand for assault rifle. It's Armalite. I know. These are semi-automatic sporting rifles. Got it. Okay. Now that we've done that, assault rifles, assault weapons are not actually broken out as a separate category in the rifle in the rifle statistics, which means that however many rifle killings there are in the United States, and it's really not that many when you compare it to other things such as knives or fists and feet. When you compare it, you're not even getting an accurate picture because it's a subset of rifles that are used in these types of killings, in gun violence in general. So that's what Roger Benitez was pointing out in his opinion, is like you're not even encompassing a significant amount of the gun crime or even the overall crime rate by doing this ban. And millions of people, many, many more people use these for lawful purposes than unlawful purposes. California's law criminalizes mere possession of commonly used arms even in the home for self-defense, and therefore the law strikes at the core of the Second Amendment. The brief says, therefore, even under a balancing approach, the court should apply strict scrutiny. By outright banning constitutionally protected arms, California has failed to engage in any tailoring, let alone the narrow tailoring required to pass strict scrutiny. Now, this is a point of argument on the Second Amendment. No one has actually laid out the level of scrutiny that's required to test whether or not a law violates the Constitution. So let me give you a brief primer on levels of scrutiny. Okay, there are three. There is a rational basis, there is intermediate scrutiny, and there is strict scrutiny. Strict scrutiny are what we apply to things like free speech, a clearly established right that is essential in the First Amendment. Free speech, free religion, free expression, free assembly. Restricting those rights has to pass strict scrutiny. Now, a strict scrutiny means that you have to have a compelling government interest, something above a legitimate government interest or even an important government interest. It has to be compelling. The government has to have a compelling reason to do what it's trying to do, and then the regulation must be narrowly tailored to accomplish the compelling interest, which means it does not step into otherwise protected activity. It has to be narrow and focused. The one way it's worded in some cases is the least restrictive means test. So the least restrictive means possible to achieve that compelling government interest. Intermediate scrutiny is a step down. It's an important government interest, and the regulation has to be tailored to achieve that important government interest, but it's not the least restrictive means. It just has to be fairly tailored to it. And then rational basis is the easiest one, which just means a legitimate government purpose. Doesn't have to be important or compelling, just a government purpose. And then the regulation has to be rationally related to the government purpose. Rational basis test is not really applied to fundamental rights, and neither is intermediate scrutiny. We go up to strict scrutiny when we get into fundamental rights that are clearly established under the Constitution, okay? The Second Amendment is fairly clear. The right of the people to keep and bear arms shall not be infringed. That should be the end of the story, but we've made it very complicated. So now we have strict scrutiny. They're arguing that that should apply. But even in DC versus Heller, Justice Scalia does not lay out the Supreme Court's framework for analyzing Second Amendment cases. And that may surprise you, but what you really need to know is that there's only about 3 Second Amendment cases, major Second Amendment cases, in the entire history of the United States. There's U.S. v. Miller from 1939, and then we go all the way to DC versus Heller in 2008, and then you have McDonald in Illinois. Well, coming out of Chicago, McDonald in 2010. Other than that, the Supreme Court does not hear Second Amendment cases. So we don't have a well-established catalog of case law to draw on for how the court should feel these things out. So they're arguing this needs to be strict scrutiny. And I fully agree. But you have to understand that there is an argument here since it's not laid out. They're making this argument based on other amendments and not by any particular ruling of the Supreme Court. And that's why I fear that the Ninth Circuit will decide it's a lower level of scrutiny on this thing. Now, Judge Benitez tried to head this off in his opinion because he showed how it fails under strict scrutiny and under the test that the Ninth Circuit has kind of been applying, this two-step test that they've been applying to gun rights. It also fails that one, but we'll see how the Ninth Circuit weasels their way through that. All right, that was a long discussion on strict scrutiny, but it's important to the conversation, and it's important to know why this is such a critical move by these 22 states. You've got 22 states attorney generals coming in saying, yes, attorneys general, coming in and saying, yes, this needs to be strict scrutiny. This needs to be upheld. This ban is unconstitutional. Here's why. Along with Arizona, attorneys general from Alabama, Alaska, Arkansas, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Ohio, Oklahoma, South Carolina, Tennessee, Texas, Utah, West Virginia, and Wyoming have signed the brief. Quote, our Second Amendment is constantly under attack from out-of-touch Californians and ignorant special interest groups, Arizona Attorney General Mark Brnovich said in a statement. America must never abandon her law-abiding citizens and their fundamental right to defend themselves. I don't even want to read the statement from California that follows because you know what? Screw you, California. Stop messing with our fundamental rights. Your right to keep and bear arms is fundamental to you, given by God, nature, or creator. Your right to bring arms to bear in defense of yourself, your home, your family, and your homeland. It's inside of you. It's integral to being a person. It's recognized by the Constitution and protected by it, not granted by it. And that is something. It's fundamental to who we are as a people. That you are not subject. You are not subject to tyranny without defense, and you are not subject to assault without defense. This is something we believe is core to humanity. And that's what's under attack when you attack the Second Amendment. At the end of the day, people try to make it about this gun or this death rate or that crime rate or whatever it is, gun violence, somehow including suicide as gun violence, all of that stuff, at the end of the day, doesn't matter. When you attack the Second Amendment, you say that that person who would otherwise be able to defend themselves is not allowed to because of my feelings. So they are required to endure an assault and even a death at the hands of another person or even at the hands of the state, of state tyranny, because you don't like a scary gun. And that is unacceptable. That is not what rights, that is exactly what rights are supposed to defend against. So we'll be watching this one. I think it'll be fascinating. I already have a feeling the Ninth Circuit is going to rule against this. If they don't, if they get a great judge panel on the Ninth Circuit, because there are some conservative judges on the Ninth Circuit Court of Appeals. If they do get it and it passes that, you can guarantee an en banc review is coming and they will go ahead and set this properly back in California. However, it'll be interesting to watch the legal arguments unfold, and hopefully the Supreme Court will be less terrible on the Second Amendment in the terms to come. They've got one Second Amendment case coming up this year, but it's about carrying outside the home in New York. It's a case that needs to happen, but there's so many other Second Amendment cases that the Supreme Court needs to take up. But anyway, I'm rambling. We'll be watching. Thank you for watching. Drop a comment below. Tell me what you think. And until next time, peace. Peace.